May I start this afternoon by offering some hand-ups, and if they're helpful, then I'll hand them up. If not, I won't. The first is that I have hard copies of the respondent's application.
Are these all the things that were sent us over lunch? In which case, I've already printed them out.
I haven't printed them out because I had other stuff on, right? So I'd be grateful for whatever you've got.
Right, that's item 1.
Yeah.
On its way up. Item 2, we have got a hard copy of part 6 of the White Book, if you would find that helpful.
Yes, we'd find that very helpful, actually.
It's not insubstantial, but
because of what we've got, I mean, no disrespect to Sir Dixon for providing us with something at least at short notice, but it'd be quite nice to have the White Book rather than sort of computerised printout from Westlaw, which doesn't include the notes.
This coming up now is part 6 of the White Book in its entirety.
Crumbs.
So it includes the notes and it includes other parts in case, because I noticed, for example, that the CPR extract, which we're very grateful to my own friends for, doesn't include 6.37, for example.
Yeah. Okay.
So I'm afraid it's a rather bulky way to deliver it, but I hope it's
very helpful
of assistance.
Thank you very much.
The third item.
And ask my clerk to put it in the file later in the day.
I'm very grateful.
Yeah.
The third item, if it's of assistance, is I have read to your lordships from the transcript of the hearing before Mr Justice Knowles. We have copies of the transcript of the 2 days, if that would be of assistance.
I don't want the whole lot, that's for sure.
We will narrow it down.
Unless you want us to. I mean,
I just don't want...
anything you refer to would be helpful to have in hard copy, yes, but...
We'll winnow that out.
If you could, that would be
Yes,
great.
I mean, the page, for example, that where I had Mr Swaroop telling...
Yes. Yes,
The
we'll winnow
debate
that out.
about
The list.
the foreign process section, that would be helpful,
Yes.
I think.
We'll do that. And I also have a page 340 for Justice Underhill for tab 22 of the
I was
supplementary.
uniquely discriminated against.
So in terms of teacher's pet, Mr Matthews done extremely well this afternoon.
Right, well, thank you. I'll try to get another tick by not spending too long over the thing. I would like to touch on 2 points briefly, very briefly, and then just go back and close on sovereign immunity very briefly.
Of course.
The first point...
Just to... Sorry, an application notice from another case has crept into what I brought with me. Yes, I've now found the correct application notice.
I would resist any requirement to meet that application.
Yes, thank you.
That's helpful.
Sorry, do go on. Yeah.
I'm grateful, my lord. The first point I just wanted to go back over was just to clarify our position in relation to the form of the order of Mr Justice Cockerell, and in particular the approach which we would respectfully adopt of my Lord Justice Phillips in relation to it, but without reliance on alternative service for the reasons I indicated previously, which we say we don't need. It goes back to the fact, and in some senses it's repetition, but it is the point that my Lord Justice Phillips has made. When the judge is asked to make an order for service out, they do so under Rule 6.37, which is one of the provisions both in the application and specifically referred to on the face of the order, which provides for the judge to make such order in relation to service out as is appropriate, as to method of service as is appropriate. And the court can and did make such an order. And the court has power, we say, to make an order for service in any way provided by English law, which would include Rule 6.9, any other mechanism, or any relevant foreign law, provided it is not contrary to the law of the foreign state in question, and provided there is no treaty, convention, etc., which requires otherwise. And that, we say, is what Mrs. Justice Cochrane was asked for, did, and it's a perfectly legitimate and proper approach within the rules, and not one to which objection can be taken. The second point I wanted to briefly go back over was Practice Direction 6B, paragraph 5.1, and the danger of the court's over-reliance in this context of the communication that your lordship has seen from the FPS. It's not at all clear how they reached the conclusion that they did. And in this context, I'd just like to briefly take the court to some materials that we do have in relation to that. The first is in the supplementary bundle, tab 2, in Mr. Snelling's fourth witness statement in support of the application to serve out, at page 56. Deals with the various different, this is in the context of the third parties, but for reasons I'll come on to show you, it applies equally in relation to the fourth party. At paragraph 164, Mr. Snelling points out his understanding from correspondence between the parties that the Republic and Credit Suisse's solicitors agree that service by such methods, that's various forms of direct service addressed above, would not be, while not valid under Mozambican law, would not be unlawful in Mozambique, which would be contrary to CPR 6.44. The Republic, including the Attorney General who represents it in these proceedings, is in a position to provide valuable assistance in obtaining the relevant visitation rights and so on. That's in relation to one of the third parties who was in prison. However, the Republic has confirmed in recent correspondence that it will not facilitate direct service at Lingamo prison on the basis that such service is not valid under Mozambican law. And so the point seemed to be live as to what was or wasn't methods of permissible live service in Mozambique. And if I then go to back in the same document to page 29, I'm sorry, at page 17, paragraph 29, Mr. Snelling, in his fourth witness statement, had set out the form of order that they were proposing, and this was all the material that I'll come on to show you in a moment. Peters and Peters were responding in their letter, which they sent to you on behalf of the Republic, sent to signature on behalf of the Republic. Paragraph 29, applicants seek an order in the terms of the attached draft order 4. B, permission to effect service on the fourth party by any one of the following means. 1, direct service in accordance with 6.423A at the Presidential Palace and or the Office of the President or elsewhere in Mozambique. So it had been very clearly highlighted to the Republic the specific method of service that was going to be adopted in relation to this. And it was, at least significantly in part, this receipt of this witness statement with all its details which triggered the letter from Peters and Peters, which we have already looked at and which my Lord Justice Underhill mercifully now has the first page of. If we go to Supplementary Bundle tab 22, this letter, starting at page 340, is a lengthy and substantial critique of all of the elements which the Republic, through Peters and Peters, considered to be wrong or inappropriate about the method in which the application for Service Act was being addressed. You'll see that it addresses questions of Section 14 immunity under the State Immunity Act, Section 20 at page 342, the tie-up with the Diplomatic Privileges Act, and then the various different analysis at some length of the immunity, and then at 346 there is a catalogue of the supposed deficiencies in Snelling 4 in relation to the fourth party, and they number A to H, and those are extensively identified and dealt with, consistent with what had been indicated in Snelling 4, consistent with what had been our understanding. It was not in this letter the Republic's position that they were in 5.1 first sentence. They did not say, the Republic is a state that requires this, therefore you can't have. Mr. Snelling's witness statement is also deficient in this respect.
Sorry, not within the Republic, not their position that what?
That the Republic of Mozambique is within the first sentence of paragraph 5.1 of Practice Direction 6B, and therefore the proposed method of service was something which was not permissible, and this was something that should be brought to the attention of the court. So, of course, they may have missed it. But this is one of those situations when we're talking about what does the law of Mozambique require and represent. We're talking about immunities and methods of service in Mozambique. The claimant in these proceedings is Mozambique. They do not raise this point. And therefore we do say that the court needs to be extremely cautious before attaching too much significance to the email exchange solicited from the respondents' solicitors from the FPS as to the proper there being a proper evidential basis before this court for a conclusion that Mozambique is indeed properly within 5.1 first sentence. Because you would have thought that that would have been one of the first things that they would have said in this lengthy critique of the very clear explanation which they had as to how service was intended to be effected in Mozambique on their head of state. And yet at no point did they, at the relevant time, raise this point. They raised many others, but not this one. And as indicated in the other passage of Mr. Snelling's fourth witness statement to which I referred, the court, it appeared that in relations between the Republic and Credit Suisse, who were also serving multiple parties in Mozambique, that doesn't appear to have been a point that they were taking in relation to that either. So that's what I'm grateful to the court for having an opportunity just to go back over. And now, if I may, just to deal with a couple of short points, final points, as it were, in relation to the respondent's skeleton argument in relation to the State Immunity Act point.
Before you leave that point about 5.1,
Yeah.
the wording of 5.1 is that the judicial authorities of certain Commonwealth states, which are not party pay convention, require service to be. I don't think you can say that the claimant necessarily represented or could speak for the judicial authorities, could you?
The claimant, the Republic, was represented by the Attorney General in those proceedings, and if anybody ought to know the state of Mozambican law in relation to such matters, one would thought it ought to be a resident in the judicial, in the Attorney General's office. So we would respectfully submit that that is the right place to have found the answer, and that was my
Yes,
point.
thank you.
So if I could just finish with a couple of very brief points in relation to the respondent's skeleton. I was touching on the point which we say is not open, and that's all I want to finish off. If I'm wrong about that, and you are minded to hear argument in relation to the application of the immunity exemption under the Act, if I could just briefly show you, first of all, the way in which it comes in Volume 1 of the Authorities, Tab 2, the Diplomatic Privileges Act, 1964, which is the relevant measures that are incorporated into the State Immunity Act by reference in Section 20, subsection 1. And in that, of particular relevance is at page 29, Article 31.
This is the Vienna Convention.
Well, it's the Diplomatic Privileges Act incorporating the Vienna Convention, exactly. And at page 29, Article 31, a diplomatic agent shall enjoy immunity from the criminal jurisdiction of the receiving state. That's the blanket immunity. He shall also enjoy immunity from its civil and administrative jurisdiction, except in the case of, and under C, an action relating to any professional or commercial activity exercised by the diplomatic agent in the receiving state outside his official functions. And there are several elements to that. And the one I particularly wanted to, I've already dealt with the others, the one I particularly wanted to pick up with was the last words, outside his official functions. If you are transposing that to the head of state, that is why it is relevant for our purposes that the relevant matters were being dealt with, or the matters complained of were prior to his period or outside his period, outside his functions as president. And it is said in the respondent's skeleton at paragraph 71(2) that my clients are wrong in a contention that a head of state's strong personal immunity can be sidestepped by making allegations that, in part, predate their presidency. Our point, very simply, is that we're not sidestepping any immunity. That's what the Diplomatic Privileges Act and the Vienna Convention provides, and it's applied with necessary modifications to the head of state by Section 20, subsection 1. So unless it's being suggested, it does appear to be being suggested, that all of these limitations are to be swept aside, that in effect, actually, it's being suggested that a head of state has complete immunity from civil proceedings. If it's accepted that that is too far and that there is some limitation, these are the limitations incorporated from the Diplomatic Privileges Act, and amongst them is that they be the exception from immunity is in relation to professional or commercial activity outside his official functions. And that same point is then made again in the respondent's skeleton at paragraph 75, where they say the notion that a sitting head of state is not immune in respect of allegations of professional activity that predate their election is also inconsistent with Article 39 as to the period during which it takes up their post, or if we don't see how that works. The short point is under 31, it is that limitation which operates. And the second point I wanted to just touch on before I sit down is that at paragraph 72 of the respondent skeleton, they say if the Privinvest contentions were to be accepted, the door is open to persons with an axe to grind to bring claims in this jurisdiction only need to be arguable against foreign sitting heads of state in respect of any election campaign or pre-presidency conduct. The short point in relation to that is obviously that's not right. It's got to satisfy the requirements of the exception in order to be subject to the exception to the immunity. It's not any conduct. It has to be commercial or professional conduct outside the scope of its official functions. And if it is that, well, that's what the legislature granted under the terms of the State Immunity Act, incorporating, with necessary modifications, the Diplomatic Privileges Act. So we say that the respondent starts from the wrong end on sovereign immunity by assuming that a sovereign has complete immunity in respect of civil claims, and that was what was intended to be achieved, whereas it is quite clear that that was not the intention of the legislature. A more limited immunity was intended to be granted, and we say that Mr Justice Voss, as he then was, correctly has identified the necessary modifications required in order to incorporate that as part of the English law as a matter of construction of the Act, the State Immunity Act and the Diplomatic Privileges Act. Unless I can assist further, for now, that's it.
Thank you very much, Mr.
I'm grateful.
My lords, if I may begin with the service point and to go directly to the nub of it, that being practice direction 6B, we submit that the judge below got it entirely right in finding that that is the only means of valid service in Mozambique under the rules, except, of course, if alternative service is ordered, which is common ground, is not the case here. 642(3) makes it absolutely expressly clear that Mozambique, which is a Commonwealth state, not party to the Hague Convention, is one where potentially there could be service direct or direct service, however that is defined, but not if required otherwise. So the rule simply knocks out that term on the basis that you have to look at practice direction 6B. And Mozambique comes, we say as the judge below found, within that category squarely. So 42 is looking at cascading down from the comprehensive scheme, as it were, looking at service through foreign governments, judicial authorities, or the British consular authorities. That's the heading. It's looking at one specific limb. And it goes very logically and systematically through countries that are party to a convention, countries that are not party to a convention, and then this other category of Commonwealth states. And there is the possibility of service direct, but only if practice direction 6B doesn't require otherwise. So we have to, as the judge rightly did, go to that practice direction for guidance. He did exactly that in his reasoning. If we look at tab 6, the judgment paragraph 9, dealing with service first, he makes the point, and he's referring here to 42(1)(b) Roman numeral 1, that is service through the competent judicial authorities, taking the wording of sub-rule 1 alone as proper construction of the rule requires in this case. So there he's saying, I've got to go back to 42(1)(b) above. That refers to service through the judicial authorities of the country in which a party wishes to serve. And then he goes straight on to say inquiries by the parties of the foreign process section have not identified a physical list, but have shown that once given the name Mozambique, the FPS is able to respond by detailing a process to cause the documents to reach the judicial authorities of Mozambique. So to say that he didn't have the practice direction in mind when he made his decision is just wrong. I mean, he's referring directly here to the practice direction as the proper construction of that rule requires him to do. And he says, on the evidence, on the materials available before me, that is the position. If anyone walks into the foreign process section and asks, how do you serve on Mozambique? That's the answer that is going to be given. There's no special category for these appellants or anyone else. It's a consistent answer you're going to get, whether it's taken from a list or from a computer system or however it is stored. And that is what the judge below is relying on. He's saying that's what any litigant, including these appellants, were directed to do. The process involves the use of agents, so not the FPS, but includes a letter of request from the senior master of the King's Bench Division to the competent judicial authorities overseas. And the next line of the next paragraph, the method used by the Privinvest Defendants in 2021 was not service through the judicial authorities of Mozambique. That is accepted, that is common ground. It wasn't the method used then. What the judge is saying is it should have been. That was the only valid method, short of alternative service, which was not granted in this case. What is significant is that Mr. Justice Knowles did, much earlier on in the proceedings, in fact in July 2022, he did say to the appellants then, look, if you think that this is valid service, well, why don't you apply to get a declaration? You can do that under 615, a retrospective application to say that is proper service. And they declined to do that. You'll see that at tab 19 in the supplemental bundle, where Mr. Justice Knowles asks, do you want to do that? And the reply, which comes back in a statement later, is we've decided not to. We're going to keep going with the process that we issued in December 2021 through the proper channels. We're going to keep going with that.
Where does this get you? It's not just it's they're being stopped from taking the point they're taking now. And if not, how does it fit in to any legal submission?
Where it gets us, my lord, is simply to show that they had an opportunity to use 615 much early on, and they didn't do it.
But I know, but where does that get you legally?
It doesn't get us much further than saying we're not in the realm of 615, so that doesn't apply. What applies is only the method that is permitted under the practice direction. At 19, just to show the point, you'll see at 310 the statement there from Mr. Snelling.
Sorry, where
23.
are we?
That's tab 19, my lord, in the supplemental one,
Thank you. Got it.
page 310, paragraph 23. The point I'm trying to emphasize here is that the appellants had applied through the proper procedure in December 2021 already. They had gone to the FPS to find out what the procedure was, and they were told this is the procedure, and they followed it. That's how
We know that, by the way.
Yes. So
Where's the evidence? I mean, it's to be inferred that perhaps that they had, but is there evidence that they went to the FPS in 2021?
well, that's how they got the the order to proceed in order to serve through the courts. In Mr. Stelling's statement at tab 3 of the same bundle, you'll see a reference there. This is in February 2021. You would take my learned friend to paragraph 164, but just below that, my lord. Yes, tab 2. I'm sorry. You'll see there an outline where Mr. Stelling says that he understands from Mozambique Council that this is the procedure to be followed. Step 1, step 2, and paragraph 170, step 3. The party seeking to effect service must then obtain a letter of request, which I understand can be obtained from the senior master of the Queen's Bench Division through the FPS. So, before they even were heard on the order to serve out of jurisdiction, they were aware of the proper procedure to be followed, and then did activate that, as we see in the later statements, by going to the FPS in order to serve the valid way, which was then properly served and accepted. And my lord, I make that point also to highlight that the burden is on the appellants to show that service was valid. Yes, my client is bringing a Part 11 challenge, but in order to proceed, they would have to show, and that's what is confirmed in the rules as well. 647 confirms that they would have to establish that service was valid.
Sorry, Mr. Dixon, is the point you're making about Mr. Snelling's witness statements in February 2021, which we got in supplementary bundle tab 2, that even at that stage he was postulating that the service would be by the procedure
Yes.
described in Practice Direction 6B, paragraph 5(1), which refers back to service through judicial channels. Is that the point?
Yes, and there's no
They
reference.
didn't do that. They served, or purported to serve, by leaving the documents with the police
Yes,
at the presidential palace.
yes.
I may have misunderstood. Forgive me if I have. They were basically went down two routes in parallel.
Yes.
I thought your point was, but do tell me if I've got this wrong, that they did in fact take the judicial authorities route in 2021. And that's what eventually, 18 months later, produced the service which everyone accepts happened. Have I understood that correctly, or have I misunderstood it?
Absolutely correctly. So they went down two routes. They went down the proper route, where service has now been effected properly and accepted, but the other route was not a valid route. And their engagement with the FPS would have made that absolutely clear, because we see from the correspondence later what they told those instructing me when they were approached. This is the only way to do it. And they, in all likelihood, would have said exactly the same thing if anybody else asked at an earlier point. This is the way you have to do it, which is then what they went on to do. And they didn't go back, to come back to my earlier point, and say, okay, well, we're so confident of the service direct or direct service that we're going to go to the judge and get a declaration on that. They didn't take that opportunity in July 2022. So it wasn't good enough then. Why is it good enough now? Is the point we're making.
I think if you look at the witness statement, I don't think that's quite what's being said, is it?
They're setting out what the procedure is.
Well, what they say is that in paragraph 161, it refers to 42(3)(a) and says effect direct service.
Mhm.
Perhaps that should be effect service direct. and it says they intend to effect direct service. And this is all, of course, that's what's being said as to the order they seek.
Yes.
And then 165 is in accordance with 6043C. Service may also be effected by other method. And then what is set out then is what is another permitted method of service. So I don't read this as saying that what was being done was pursuant necessarily to 5.1 of the practice direction.
They make no reference to the practice direction at all, and it was there for everyone to look at their time, and no one delved into it, no one mentioned it. It wasn't raised at the hearing before Mr Justice Cockrell either. So what they are saying is there are two routes that can be followed. We can look at doing it directly, providing it's not contrary to the law of the country there, or we can go through one of these methods.
One has to look at this quite carefully, isn't it? Because this was covering more than one party.
Yes.
Yeah.
So some of it, they certainly were hoping to serve direct on those parties in prison.
Yes, but that's significant, my lord, in that at the end of paragraph 164, the Republic makes it very clear that they will not facilitate direct service, that such service is not valid under Mozambique law. So they knew then already that it wasn't valid under the law of Mozambique, and that this was the procedure to be followed.
It's only oddly praised 163. They intend, but 163 says they intend to effect direct service on the 3rd, 5th, and 8th defendants. And yet, in the next paragraph, they're saying we've been told we can't.
We can't, and there's a letter to that effect, which we
It
don't
might
have
be
in the bundle.
better would be the applicant's original intention was to. But anyway, this is well, the case is not going to turn on the.
No,
That's why I wonder where this point really gets you. It's almost just a debate.
I was just highlighting it as context, and to get to
Context is what I call the debating point.
relevant context in order to highlight the point that what is really being said now is that we haven't produced evidence of what are the requirements. Well, we have one through the FPS correspondence. That's the first point. But secondly, the burden is on the appellants. If they take a different view that there's no such requirement, well, why didn't they get evidence of that? I mean, we're saying there wouldn't be evidence of that because the position is very clear. And they've had plenty of opportunities going right back to February 2021 to get this sorted out. They could have brought it before the court in July 2022 already, and they've left it till the very last moment to...
I thought you were about to make a different point, which was in a sense Mr. Sterling's witness statement is evidence, if any more is needed, than what the FPS has said, because they say, again, do tell me if I've got this wrong.
They do set out exactly the same procedures they set out.
Yeah, and they say that's what they understand from Chancellor in Mozambique.
Precisely. So it's completely consistent with the email, although it doesn't mention.
It's service through the Mozambique court, that's the point.
Yes. It doesn't mention practice.
And in the context of the President, they deal with that expressly in paragraph 184 and following.
But then to come on to the key point, which is that there doesn't have to be some form of list or whatever other requirement in relation to the mechanism to ensure that the only form of valid service other than alternative service is through the courts. The requirement is what the FPS conveyed to us and what they would have conveyed previously and what they would convey to anyone now. Why else would they say that if there was another way of validly serving? Of course, they're not going to go into alternative service. That's not their role. But they must have been told that's the requirement, and that's why they pass it on to potential litigants. Their email, and that's at tab 7, we looked at that earlier, and we can go back to that at tab 7, page 68.
Yeah.
sets out a series of steps, a list, as it were, of what has to be done, which would be replicated in any case where such a request was made. These are the steps that you have to go through. Here are the forms. In fact, form N224 was enclosed as well, but it wasn't included in the bundle. But that form is there as well for the solicitors to fill out. Then the letter of request, which is specifically addressed to the competent judicial authority of, and the country has to be filled in. These are steps and procedures that are replicated if any request is made, whether, say, it comes from a database or a list or a computer. If one is asked, how do you serve there? This is what they're told to say. And as was brought out earlier, it's made very clear the only service method, that's the third line in the email, available in Mozambique is agent to agent, which means you have to do it, go to an agent, that agent then has to go to court. We're not going to get involved, as they often do in other situations, but it's for you to then have to pursue through the courts. And that is exactly the procedure that's set out in Mr. Stanning's earlier statement. Entirely consistent. It hasn't changed. It's there on the records. And that is why the judge was entirely correct in saying that the practice direction is engaged. And when you look at the practice direction, direct service direct is knocked out. It no longer applies here. We have to go through that route. And if that doesn't work, well, then you can come back. There's an open door to come back and try alternatives. And then we're into the realm of what is contrary to the law and whether it's positively prohibited. That is why we're saying none of that case law is relevant, because we're not in that realm. We're also not in the realm of having to define what is service direct or direct service. We did put in submissions on why the Ghana case doesn't clarify matters, but we said there's no need to decide that matter because the practice direction is clear.
If you're right, then the closing words of 642.3 apply, don't they? Method of service permitted by paragraph 1B, which is through judicial authorities, not available unless practice direction 6B provides otherwise. And then when you go to practice direction 6B, paragraph 5.1, then that contemplates expressly that
specifically highlighting the competent judicial authorities as Mr. Justice Knowles
require service to be in accordance with that's judicial service through the judicial authorities. So I mean, that's making clear that's what's required, and you would say, well, that's exactly what is said in the third paragraph of the email. The only service method available in Mozambique is agent to agent.
Yes. So
It's a suggestion there where you could also serve direct if you felt like it.
No. And the FPS would be open to say, if that's what they've been told are the accepted methods interstate, to say, well, no, actually, if it comes to a question of Mozambique, you've got a whole range of options. You can do this or that. They didn't say that. So the only way to do it is this way. And there's no exception. These appellants can't come in with a new category to suit their needs. It's a slightly convoluted route, but it's very clear in the end. It knocks out 1B and 2 initially, but then it brings in to play, not 2 again, but 1B1, which is through the judicial authorities of the country. It's only that part that comes back in. And that's why the judge below said, the proper construction requires me to look at that provision again, having now consulted practice direction, and it refers to service through the judicial authorities of the country, and that wasn't done. And therefore, he said, based on materials I have before me from the FPS, that is clear. And yeah, the earlier point I was alluding to is that it doesn't assist to say, well, we should have brought more evidence of the requirement. There was ample evidence before the court, and there's no reason to, in those circumstances, find that there was any error. The judge below was perfectly entitled on the available information, which was very clear, to make these findings. And we therefore say his judgment in this respect on service should not be disturbed.
Yeah. Well, it looks as if, I mean, the email from your instructing solicitors on the 31st of July, which is at page 68, right at the bottom,
Yes.
at 69, they'd obviously had information previously. Because
Yes.
they actually say, don't they, because they ask the foreign process section to confirm that their understanding is correct. And they say in the middle of that paragraph, the FPS has long operated on the basis agent-to-agent service is the only underlined method by which English procedures can be served validly in Mozambique. Well, that was their understanding.
Yes, my understanding from those instructions
No
was
doubt from previous discussions, and back come the FPS, the only service method available is agent-to-agent. And you would say, well, what more evidence do you need than that?
yes.
And that previous experience, apart from anything else, will have been the experience they got at 2021 when they
Yes.
originally issued the letters of request, which eventually produced the service in 2023.
Yes.
Yeah.
I understand that there had been conversations previously which were then put in writing to seek to record it, and that's what then came out, was this email in response. So that's where it originated from. And
Well,
really what they were saying,
surely what happened, if I haven't put it away now, but simply what happened is they sent that email, they obviously had a conversation because the reply refers to the email and our conversation.
Yes.
And they got that back the same day.
Mhm.
That's all that happened, isn't it?
Precisely, that's exactly what happened, and it sets out, as I say, a series of steps which seem to be formulaic. This is what applies all the time for this country. Anybody else comes here and asks, they'll get the same answer as Mr. Stelling got a while back.
Well, it looks as if they were, your solicitors knew about the agent-to-agent point, had known for some time. In the last paragraph of the email, they actually say, in addition to this long-standing position on agent-to-agent service, there's now an additional requirement that any English proceeding must be provided with a letter of request signed by the senior master.
Yes. And then got a
So it
copy
looks
of.
as if this is a long-standing arrangement or long-standing position as described.
Yes. And as was ventilated in the court below, it arises in the context of a country that's not a common law country, it's a civil law country that's part of the Commonwealth. And in civil law countries, as we know, generally, service can only ever take place through the court. So that's why that's a requirement. If a foreign litigant arrives, they have to follow the same procedure.
Yeah.
And hence, why the practice direction allows for that list, in inverted commas, of some of those countries, whether that be others like Rwanda or a few others. I expect it's quite a limited list.
Can you help me with the wording of 642 for a moment?
Yes.
It's concerned with service to foreign governments, judicial authorities, British consular authorities. And sub-rule 1, where a party wishes to serve a claim for, it may be served. So it's permissive through the authority, etc. And then again, rule 2, same format. It's permissive. When it comes to rule 3, where a party wishes to serve the claim form and it sets out the conditions, the methods of service permitted by 1B and 2 are not available. And so it says, and the party or parties must effect service direct. Then the caveat, unless practice direction 6B provides otherwise. And 6B is providing for service through the judicial authorities. So my concern about that is, what it's saying is, certain service isn't permissible, it isn't permitted, so you must effect direct service, unless, seems to me, qualifies the what's available, not necessarily what you. I don't necessarily read that as saying if section 6, if practice direction 6B provides otherwise, there is a route for judicial service. It doesn't necessarily, I don't read that as necessarily meaning that you can't serve direct.
But practice direction 6B then has to be, now that it's in play, studied in terms of its specific terms. And it then provides for only one method of service to which the judge below referred, and that is through the judicial authorities.
I understand that, and I can see the argument, but what that means then is that the route under 1B and 2 is available.
Yes.
So the unless is caveating that as well, isn't it?
Yes, well, what the unless is saying is that 1B and 2 could be in play, but then the practice direction only provides for one route for countries that have so required. This is Commonwealth countries that have so required. So not convention countries, civil procedure convention or treaty countries, which is in one. Not any other arrangement, bilateral treaty arrangement. This is only for Commonwealth countries. So it then narrows it even further and explains it.
I mean, the provisions have to be read together, don't they?
Yes.
And although, I mean, my lord's absolutely right in one sense that 642(3) A does, or the closing words of that provision do, if they were read in isolation, suggest that you can serve in one of two ways. You can either serve through the judicial authorities, or you can have direct service. But when you look at practice direction 6B, that says certain countries require, the judicial authorities of those countries require service. So that's mandatory.
Yes.
So if you read them together, where you get to is in the case of Mozambique, service must be through the judicial authorities.
Yeah.
Full stop.
So you need.
And that also covers 640 subparagraph 3C,
3C.
any other method permitted by the law of the country
Yes.
in which is to be served, because Mozambique requires service
Yes.
through the judicial authorities.
So the only other way of getting a different method would be to apply under 615.
Well, that's a different.
Yes.
That's always a different sort of
Yes.
set of provisions, because that's effectively the English court saying whether the sort of difficulties of service which need to be demonstrated before you can go down the alternative service route, where it's so difficult to serve in the foreign jurisdiction, the English court will permit alternative methods of service, provided they're not illegal under the law of the country in question.
Yeah.
So, for example, service by email. But not in the 615 territory.
But read together, that is correct. I mean, that is what the judge below, in essence, found. And there are no authorities on this particular point. The authorities that are referred to are all in the realm of looking at, well, if you can't do that, then you
Nearly all alternative service authorities are.
yes, the alternative service. Right. So Lord Clark's finding is very clear, saying that you have to go through all of the methods under the rules first, before we shift over into this realm. And only then, and says only then, can you look at questions of whether it's positively contrary to the law. So we're not in that territory where we have to consider what are all the various provisions that might make certain service contrary to the law in Mozambique, because here there's a very clear method that is permitted that has to be exhausted first, which it was in the end, and service was effective. My lords, the only other provision in part 6 would be 647, because I referred to this earlier with regard to that the claimant has to establish that the claim form has been duly served in accordance with this part. So just to underline the point that we don't have to bring any evidence regarding what service is valid or not. That is for the Part 20 claimant to do. In this case, there is, as we've outlined, more than sufficient evidence to clarify that the method of service used was not the valid one. And if there was anything else, then, as I've emphasized, it was open to the appellants through all of their contacts with the FPS to make other points. And it's wrong of them to criticize the judge for, based on the materials that were before him, so that was insufficient, and that he came to the wrong conclusion based on that material, when the material speaks for itself. My lords, unless there's anything else on the service point, I mean, we do have some of the other arguments in relation to Section 12 of the State Immunity Act, and some other arguments which are set out in our skeleton.
But if you're right on the main point, then we don't really need to consider those.
No. So that then leaves immunity, my lords, and I can do no better than go through the reasons that were set out by Mr. Justice Knowles below, and that's at the judgment paragraph 25 onwards, where he has looked at the conflicting positions of the Master of the Rolls and Lord Briggs, as they are now. So really the obiter of the High Court versus the obiter of the unanimous Court of Appeal. And he then goes through the different reasons why he decided in favor of the president. And I think it is vital to underline here that we're not talking about whether acts are official acts or not. We're not talking about conduct immunity or immunity rationale materiae, which was the real subject of the Pinochet case.
Yeah.
We're talking about the fact that the president is a sitting head of state in a very particular position where international law, as was outlined in detail below, has recognized that the immunity for all acts, whether private or public, while the head of state is in office, it's a status personal immunity, is absolute. That there are no exceptions as a matter of pure international law. That subsists while he is in office, and not after that. After that, there might well be arguments over whether acts are official or not and still qualify for immunity. And some of those matters were ventilated in the court below, but it wasn't necessary to decide that in the end. We were only focused
and Mr. Matthews is right that they're not in fact taken in your respondent's notice.
Well, in our respondent's notice, what we are raising here in response to an appeal is that if the judge was wrong on Section 20, then we say, well, of course we have to look at all of the arguments we raised, including whether this is in fact a commercial or professional activity.
I didn't notice that in the respondent's notice. I'm sorry. It's there, is it?
No, it's not there. But what I am putting forward is that is it necessary to put all of the arguments we raised below in a respondent's notice, where the decision was only on in the end, because that's all that needed to be decided, head of state immunity while in office. There were a number of other arguments raised which also would have given the president immunity in our submission. So if we're wrong on head of state immunity, then there are a number of other arguments that would have to be considered, which we say we can rightly raise in our skeleton in response to the appeal points that are
That's
made.
the whole point of a respondent's notice, isn't it?
Well,
To say the judge should have found in our favour on this ground as well, or could have done.
it could have done, but the
Yeah,
head of state immunity point was the overwhelming one.
yeah, well, that's fine. Perhaps are we misunderstanding one another? The judge decided to be economical and decided just on a single point. You're perfectly entitled
Sorry.
to fight it on that battle, but if you lose on that battle, you can't now ask us to decide it on another basis, even though it's before the judge, can you? Say, oh, because the ultimate question is, did he or didn't he have immunity? And these are all sorts of reasons why he didn't.
Yes, they're different categories.
So, exactly. So if you want us to decide the immunity question on arguments that were run below, which the judge didn't trouble with, you've got to put them in a respondent's notice, haven't you? That's what a respondent's notice is for.
Yes, all I can say is that we do refer to this, but only in a footnote in our respondent's notice, that we did look at asserting immunity in other respects as well in the court below, but it's not there as a specific ground. But in any event, we say we have a clear basis.
Well, exactly. If you win, none of this matters. I just wanted, though, to be clear what the formal position was.
Yes.
Yeah.
Formal position has been taken against you. These points are not pleaded in the respondent's notice, and although Mr. Matthews made a few points about them as it were in passing, it was all without prejudice to that.
Yes.
I just wanted to be clear whether you were saying that the points were open to you and you were going to argue them.
No, if they are not referred to in the specific grounds, I fully accept that. I will only say, for completeness, that we have referred to some of the arguments in other arguments that we made in footnotes, but not as specific grounds. So I'm not going to pursue that any further. I will focus on head of state immunity. As I was saying, it continues throughout the term of the president's office, and it doesn't matter if the acts are public or private, if they took place before he came into office or while he was in office. That is the pure position as a matter of international law, which was recognized in Pinochet, even though it did not have to decide the issue of head of state immunity while in office, because General Pinochet had already left office. They had to look at it in relation to the whole gambit of international law applicable to heads of state. So that is the starting point, and it's where the judge below started as well. And there are essentially 7 reasons that he outlines in those paragraphs from 26 onwards. Firstly, indicating in paragraph 27 that Parliament gave statutory force in the United Kingdom to customary international law as to the immunity which heads of state and former heads of state in particular enjoy from proceedings in foreign national courts. That was the intention behind the enactment of the 1978 Act, was to give force and effect to the current position as a matter of customary international law. And that was the position at the time. I mean, it's wrong to suggest that there was confusion at the time. Rather, the argument is that over time, there might be certain exceptions that arise as a matter of international customary law, which I'll comment to now. One of them is in relation to the commercial activities of a state, not the private acts of a head of state. But there was no evidence of the law developing to the point that it covered the private acts of a sitting head of state. So that was the first point. The second, in paragraph 28, is the rationale behind this. the now oft-quoted dicta of Lord Phillips and Lord Justice Lawrence Collins in Aziz versus Aziz, that the immunity is functional in the sense that it has a clear function in international relations to protect the ability of the head of state to carry out his activities and to promote international cooperation. So that is the rationale behind it, and the reason why any interference with it must be interpreted in the narrowest of all fashions. Then there's the point which my learned friend raised about the amendment, that initially it was only going to apply to heads of state when they were in the United Kingdom. And an amendment was introduced to say, no, we have to cover the situation across the board for a head of state to have immunity wherever the acts might be committed and wherever they might be. So that was highlighted as a very significant indication that there were not to be any erosions read into it without Parliament expressly legislating in that regard. And it was open to Parliament to say heads of state will no longer have those immunities. But they didn't do that. What they did instead was say that heads of state have the same immunity that an ambassador has in jurisdiction, which is a complete immunity, except for private acts that are done in the receiving state. And what the judge below found was that there was no need to delete that, because in fact, no modification was required to the rule to say that the head of state was in the same position as his or her ambassador. That if you came within the jurisdiction and performed certain acts in the jurisdiction, you may then lose your immunity in exactly the same way as your ambassador will. But you shouldn't be in any worse position than your ambassador, who has immunity everywhere else in the world if you're the head of state. You should have the same immunity around the world. So no need to make any modification. We say in any event it's not necessary, as we submitted below, for the court to decide what the absolute position is, because on the facts in this case, and this is common ground, none of the alleged acts took place within the United Kingdom. So we're not in that world where we have to decide whether or not, if the acts were here, would the immunity still bite or not. They all took place outside of the United Kingdom. Paragraph 33, the judge highlighting that this is not to say that there are no consequences to acts that are taken. There are some limitations. It only persists while the head of state is in office. And it doesn't mean that they have immunity in their own state. Then, sixthly, Trentex and the commercial exception. That's section 3 of the SIA. Yes, that exception was introduced. Commercial activities of states are now fair game in jurisdictions around the world, but they have to be purely commercial, not governmental. So that's a question of fact in every case. But that section does not erode head of state immunities, which is in a different part, part 3 of the Act, where there we are talking about the office of the president and his ambassador for their public and private acts. So no basis, Lord Justice Briggs, as he then was found, for finding that Parliament has, in enacting section 3 in part 1, crossed it over to part 3 and taken away in relation to any commercial activities, whether private or public, anywhere in the world, the activities of a sitting head of state. And here, paragraph 36, the seventh point, no evidence of a practice under customary international law that even though the winds of change were blowing on the commercial front for states, that it went so far as to remove for sitting heads of state their commercial activities anywhere in the world. Yes, an exception was made for ambassadors, because that's also strictly prohibited, that ambassadors should not be involved in the receiving state in commercial activities, but not extended to heads of state anywhere in the world. And paragraph 38, finally, that the test is necessity. It's not whether we would like it or whether that's something that should change in the future or are the winds blowing in that direction. The threshold is necessity in order to make a modification, particularly one as far-reaching as removing from a sitting head of state, as would apply to any sitting head of state, then, wherever they went in the world, their absolute immunity. A different matter, of course, when they leave office and whether the acts are still official, that's for determination based on the facts in each case. So that is why we say Mr. Justice Knowles was correct in law in finding that there was no need to make a modification. It certainly wasn't necessary to just delete receiving state and open up litigation anywhere for any acts while a sitting head of state is in office. We have other arguments that we've outlined. I'm not going to go into those any further, but our primary argument is that the judge below was correct in law. No error has been identified. It's really been tagged on as an additional ground of appeal to grounds 1 and 2 on service, and is really a plea by the applicants to say, we'll follow Mr. Justin Foss's decision as he was then. And it really does to know more than that. They haven't mounted any arguments to address these very clear findings that were made by the judge below. So unless I can assist further on immunity, those are our submissions on immunity.
Thank you very much, Mr. Dixon.
Thank you.
I first try to introduce a degree of clarity into the interpretation of Mr. Snelling's witness statements, which appears to have been taking place. The point was made by my learned friend that the application of Practice Direction 6B, and in particular paragraph 5.1, was not addressed to Mrs. Justice Cochrane. I have shown you the reason for that, which is that the underlying correspondence and communication, which is referred to in Mr. Snelling's witness statement and was exhibited to it, but is not in the court, is that the Republic, the state itself, was saying to Credit Suisse in relation to service in Mozambique that Practice Direction 6B was not applicable. That's what Mr. Snelling was addressing in his fourth witness statement at paragraph 164, supplementary bundle 2, tab, page 56. Your Lordship will appreciate the starting point of this is that for 5.1 to apply, it is not enough that Mozambique permits service through the judicial authorities. It is required, sorry, to avoid double use of that expression, it is that the Mozambique law would have to require that service take place between the judicial authorities and that it not take place pursuant to 6.42.3. So the fact that Mozambique permits service through judicial authorities does not go so far as to say it requires it. So the context of Mr. Snelling's fourth witness statement, paragraph 164, was that from correspondence between the Republic and Credit Suisse's solicitors, such methods, while not valid under Mozambican law, would not be unlawful. In other words, they were not prevented from taking place by direct or service direct, but they were not expressly permitted, and therefore it could not be said that Mozambican law required service by such and such a route rather than another route. It permitted it, but didn't require it. And again, the letter which your Lordship saw earlier from Peters and Peters on behalf of the Republic from the Attorney General, at no point in response to this approach as to how service was going to be effected in Mozambique, alerted or suggested that Mozambican law required rather than permitted service through judicial authorities. And if ever anywhere you would expect to find Mozambique stating that there was such a requirement rather than possibility, then it would be there, because they know their laws and they know whether they require it or not. And they didn't say they did. And so it is not surprising that nobody addressed Mrs. Justice Cochrane on Practice Direction 6B and 5.1, because the Republic was disavowing any right or entitlement of the Republic to insist upon service being through judicial authorities rather than by any other means. And so no one considered that paragraph 5.1 first sentence arose. Now, what my learned friend has then averted to is the bit below that on page 56, in which Mr. Snelling identified, not on the basis of communications with the foreign process section, but on the basis of communication with Mozambique Council, as he identifies in paragraph 166, that there is a route through diplomatic channels for service. And therefore, there was no obstacle to the Privinvest parties pursuing parallel routes to service if the President's diary had come more quickly available through the in communication with the judicial authorities in Mozambique, then that method of service may have been effective. So also was the method of service that was in fact effected, namely by dropping off the relevant documents at the presidential palace.
I thought what Mr. Stanley was setting out here was the route of service other than through diplomatic channels.
It's other than through diplomatic channels, but there is another process permitted, which is the service through the mechanism identified in paragraphs 168 following through judicial authorities. And that's then step 5, for example, paragraph 175, is then a letter to the public prosecutor's office. And that's how it gets communicated through. Now,
168, something it says is, I understand from Mozambique Council that if service is not effective through diplomatic channels, the documents must be legalised before they can be served.
Yes.
Which picks up on what he says at the end of 167. Parties seeking to effect service must take the steps below.
But this is
that
all
sounds like a requirement.
This is all under the context of paragraph 165, which is any other method permitted by the law of the country in which it's to be served, but which is not then dealing with direct service. That's already been dealt with in the period prior to that. So it is not correct to say that any inquiry...
You can have a method of service that is required to be in a particular format in order to be valid. It does not mean that it is unlawful to deliver a document to somebody's door.
Yes,
Radford comes across this, I think, in relation to service in Switzerland, where I
Yes.
think it is actually criminal
yes,
to purport to serve a document on somebody.
yes,
And that's the distinction we're usually talking about, is between what is required to effect valid service under the law of the foreign country.
yes. I entirely agree. I'm in furious agreement with your lordship. That is focusing on a permitted method of service. But
But so is paragraph 5.1 of 6b.
that depends whether it's required to be rather than any other means. In other words, one's not allowed to go through any other route.
But again, that's required in order to be valid, isn't it?
Well, that begs the question,
different-
why would it be required in order to be valid when the English court isn't concerned whether it's valid as a matter of Mozambique law, it's concerned whether it's valid as a
Well,
matter of
that's
English law?
why I think when you come back to read 642, is whether or not it is actually saying you can't serve direct.
Well, if you look at 167, I understand service of English proceedings on resident Mozambique can be carried out through methods other than through diplomatic channels. The party seeking to effect service must take the steps set out below. And although it's true that the steps set out below don't actually mention in terms service through the judicial authorities, that's essentially what's being described. Because you have to go, amongst other things, look at the steps. You have to get an opinion from the public prosecutor about the letter of request from England. And then step 6, you have to go to the Mozambique court to decide whether or not the letter of request should be complied with. And the court may say no, but if the court says yes, then the court clerk of the court of the area serves the relevant documents. So it's all done through the judicial authorities.
This is the route by which it is done in accordance with what the Mozambican law anticipates. But that takes you back.
Requires.
Well, that takes you back to
Anticipates, well, the laws don't anticipate things, laws require
That's why he
things.
says, I mean, this is your own solicitor's witness statement. Parties seeking to effect service must take the steps set out below. Not may, or you know, this is optional, you can do it by all sorts of other routes.
Well, the starting point of this is that is the alternative being postulated to what has already been addressed, namely the direct service route, which is paragraph 164. And that is where the question of validity or invalidity is contrasted with unlawfulness. So to take the example that my Lord Justice Phillips gave of Switzerland, Switzerland is a prime example of somewhere which actually not only says this is what you do to effect valid service, but it goes further than that and it makes other steps taken within its sovereign territory to effect service actually positively unlawful. And that is what is outlawed. That is by the mechanism by which the court here says, well, we're not going to require that to be done. But it is a completely different approach, and that's the premise upon which the Republic itself had not raised the point about PD 6B and 5.1 and did not pursue it through in the criticism of Mr Sterling's proposed approach to service, when they raised all those other points. And that is simply because, whilst it's recognised that it's not the method anticipated by Mozambican law, it is not made unlawful.
This part of the witness statement, insofar as it talks about direct service, it's paragraph 163, direct service upon the 3 third parties who were in prison. And what was said at the end of 164 is the Republic has confirmed in recent correspondence.
Yeah, but that's because paragraph 184, it says paragraphs 160 to 176 apply mutatis mutandis to the fourth party.
Well, it will not facilitate direct service at the prison on the basis such service is not valid under Mozambique law.
Not valid, yes. But that doesn't make it unlawful or contrary to law.
Well, where's the unlawful? The unlawfulness comes in, obviously, if we're looking at 640, 4 doesn't actually use the word
Yeah.
unlawful, it's contrary to the law, but the means by which you can do it are in 640 sub 3,
Right.
and that uses the word permitted.
Well, that's
And
one of the
permitted
ways.
in that context clearly means valid.
Yes, that is one of the routes, and we're not suggesting that the route that we're not addressing whether Mozambique law permits this particular type of service, because that's exactly why it's
It
contrasted.
doesn't permit this kind of service.
Correct, that's what 164 says, and we've already always acknowledged that.
Well, I must say I got lost as to where all this stuff about Mr. Sainsbury's statement goes, but still.
Yeah, likewise.
What I'm trying to clarify at the very basic level is that Mr. Snelling did not apply to the FPS and get an answer in 2021, which was one of the points being suggested. Nor is it clear that anybody applied in 2021 and got an answer from the FPS as
So
to
what?
was or wasn't.
So what?
Well, your lordship raised the question, and therefore I'm answering
Well,
it.
no, I raised the question with Mr. Dixon where all this is going.
And well, yes, but your lordship did ask the question of whether the emails from Celador indicated that the inquiry had been made in 2021. with
Yes,
respect-
but I was exploring what Mr. Dixon's point was. I wasn't accepting Mr. Dixon's point went anywhere. At the moment, I don't see that it does, but
Well, I'm grateful. I mean, we do say that there is a fundamental difference between require, where the doing in some other route would be unlawful, and permit, and they are different words. And we do say that the position is that the Mozambican authorities, at the best, permit service by the method identified,
Which service
but
is
do
that?
not make
oh,
unlawful.
hang on. Yes, but it doesn't matter whether they make it unlawful. Unless anyone is relying on 640 sub 4, question of unlawfulness is irrelevant. You're not saying that it's a permitted method in the sense of a valid method under 640 sub 3C, 3 sub C, that's what we just established. And then if we're looking at 642, and through 642 at the practice direction, we're looking at what the foreign authorities require, because that's the language of the first sentence of 5.1, i.e. in order for it to be effective. So I don't quite at the moment see where the question of positive unlawfulness comes in. We're dealing entirely with what will be effective service according to Mozambican law. I've obviously missed something.
No, well, service which is not valid is not permitted.
Quite.
It doesn't follow from that it's unlawful, it's just not good service. As my lord says, 640 sub 4 is really a red herring.
Respect, I'd agree with that.
Then why are we addressing it at all?
Yeah.
At this point, we're addressing the meaning of paragraph 5.1 require.
Yes.
Well, it's a bit more than that, isn't it, Mr. Matthews? Because you need, as I said to Mr. Dixon, you need to read these provisions together. So it's not just that provision, it's 642 sub 3, which is applicable to this particular jurisdiction. The methods of service permitted by paragraphs 1b and 2 are not available, and the party or party's agent must effect service direct unless practice direction 6b provides otherwise. You then go to 6b, and that says judicial authorities require service in a particular way. So if you read them together, it seems to me what they're saying is that so far as Mozambique is concerned, service direct is not permitted.
I can say no more than the fact that your lordships are equating that which is
And that
required
seems
as
to
the
tie in with
opposite.
what said under 164 of Mr. Snelling, that they were saying then that service direct service was not valid under Mozambique law.
Yes, and what we say is that for the purposes of 5.1, you require more than that in order for 5.1 to be triggered. As I say, if we get into this, you already got my first point that we don't get into this because the 5.1 is self-defining and it's not satisfied anyway. But if we're into the substantive question of whether 5.1 is satisfied, then it has to be established that that which is done, namely direct service, is contrary to that which is required by, and therefore contrary to law. But that's taking me back over the case I was addressing earlier, and I don't propose to do that further. What I was trying to do was to clarify the scope of this communications and make it clear that nobody seems to have addressed the FPS in 2021. And the reason for that was because the Republic was saying that it's not something that they require. And indeed, that is not something in the letter they indicated was in any sense a defect in the application that was about to be made to Mrs Justice Cockrell, where they made all the other points that they thought were criticisms. 6.47 was the next point my own friend dealt with, and that's a question of burden. If your lordships look in the note on 6.47, your lordships see that this will be satisfied. Page 316.
Yeah.
The written evidence in the second paragraph of the note must show that the claim form has been duly served. And then it says this, halfway through, this requirement will be satisfied if written evidence is produced which shows that such steps as the court may have specified in the order made, in this case under 6.15, because it's dealing with alternative service, have been complied with. We do have the certificate of service specifying that the steps ordered to be taken in the...
I'm sorry, Mr Matthews, I'm not following where you're reading from.
I'm sorry, my lord. 6.47, halfway down page 316.
Yes.
There's then in the note at 6.47.1,
Yes.
bearing in mind this is being relied upon by the respondent as showing the burden is on the claimant to prove proper service.
Yeah.
The second paragraph of the note says the written evidence must show that the claim form has been duly served out of the jurisdiction in accordance with this part. And there's then a discussion of how that can be achieved in the context of 6.15, but I would say that it's equally applicable even if 6.15 is not engaged, where permission to serve out has been given. So the requirement will be satisfied if written evidence is produced which shows that such steps as the court may have specified in the order have been complied with, and we say that we have provided such a certificate because the certificate which your lordships have in the supplementary bundle at tab 23, page 348, provides exactly that certificating evidence. That which the order required to be done has been done.
Another way of looking at it is that you served precisely in accordance with the order giving you permission to serve out.
Yes.
So you might say the burden of showing that was ineffective must be on the party seeking to set it aside.
Yes, well, we do. And then turning to sovereign immunity, it does appear from the argument of my learned friend that they are arguing that the sovereign head of state, whilst head of state, has an absolute immunity, despite not only in criminal matters, which by customary international law they had, and by the State Immunity Act they have, but also in civil matters in connection with commercial and professional activities. And that, we say, is simply unsustainable on the statute, both the State Immunity Act and the incorporated part of the Diplomatic Privileges Act. It overlooks completely the distinction between criminal and civil, certainly in the criminal context because of the issues relating to restraint of person and so on. It has always been accepted that there is an absolute immunity, subject to what we then come on to in relation to the different situation being dealt with in Pinochet, which wasn't concerned with the position of a head of state, but a former head of state. But in the civil context of commercial and professional transactions, one has only to look at the sections cited from the judgment of Mr Justice Voss in the judgment of Mr Justice Knowles in tab 6 of the core bundle, pages 57 to 58, where Mr Justice Voss analyses this position in relation to the immunity of the head of state in relation to commercial transactions, and says that in the context of trend text, there was a respectable argument just before the enactment of the statutory State Immunity Act. Sorry, it's in the core bundle at page 57, bottom of the page, going over to the top of page 58. At the top of 58, there was a respectable argument just before the enactment of the SIA that Customary International had changed by that time so as to present sovereign states and their emanations, i.e. heads of state, claiming immunity for their commercial activities. Trentex did not deal with the personal immunity of the sovereign, nor with the personal immunity of a sovereign's family members. That exercise now requires Section 20 subsection 1 of the SIA and Article 31 of the Vienna Convention to be properly construed. And so what the Mr Justice Voss then was at paragraph 140 goes on to say, the first point arises from the comparison between the immunity and its exception in respect of sovereigns acting in their public capacity, and the immunity under Section 20, subsection 1 of the SIA and Article 31 of Schedule 1 to the DPA in respect of sovereigns acting in their private capacity. There is no territorial restriction to the commercial exception under Section 3. That's the one applicable to states. It is therefore hard to imagine any reason for such a territorial restriction under Section 21 of the SIA that's relating to heads of state. And the point being made simply that the State Immunity Act has, insofar as there ever was, blanket immunity for civil suit in relation to heads of state. That has been curtailed by both in relation to heads of state and indeed in relation to states, and it's statutorily recognised by the State Immunity Act 1978, Section 3 in relation to the state, and Section 20, subsection 1 in relation to the head of state. And so the position is quite clear. There is no acceptance or recognition or acknowledgement of the existence of an absolute immunity in relation to all civil matters for heads of state. And as Mr Justice Voss says halfway down, it would, in my judgment, be remarkable if Parliament could have intended no limitation vis-à-vis commercial acts on the personal immunity of the sovereign, his family and private servants against the context of imposing restrictions on the state. One of the big changes introduced by the SIA, even if it was a codification of existing principles, was the commercial exception. An exception of that kind was expressly applied both to states and sovereigns exercising public functions and to sovereigns acting in their private capacities. The complete abrogation of the uncertain extent of the exception to personal immunity as existed at the time in 1978 seems a most improbable parliamentary intention. And so essentially that's all we say in relation to that point. That is what operates in the context of the State Immunity Act 1978. Parliament legislated both to restrict the immunity in civil matters in relation to states and also to restrict the scope of the immunity in relation to civil matters limited to commercial and professional by analogy or by incorporation of the Diplomatic Privileges Act and Article 31 of the Convention to give that parallel effect. And what the respondent's approach to this seems to adopt, and indeed to that extent also the judgment of Mr Justice Knowles, is to reverse that and say that in fact there's blanket sovereign immunity.
But this, I follow that, and entitled to raise that issue, and it may be that it goes beyond what's permissible. But the question that we have to answer surely is a much narrower one, isn't it? I mean, really it comes down to whether Mr Justice Ross or Lord Justice Briggs are right as to what necessary modifications, if any, are to be made to the provisions of the Diplomatic Privileges Act and the Vienna Treaty as incorporated in it.
Yes,
For
it is
certain purposes, and Lord Justice Briggs recorded in the judge's judgment of paragraph 23 said, well, this may no doubt have been desirable and sensible, but it wasn't necessary.
Yeah, there clearly is some necessary modification.
And that's to do with the temporal limitation.
Precisely.
Of the territorial limitation.
Precisely. And so, what we, with respect to Mr Justice Voss got entirely right, is the absurdity of the situation that you would have states not subject to immunity in relation to their commercial activities, but sovereigns subject to immunity in respect of their commercial activities, which would give them a greater level of impunity from suit than states enjoyed, despite being the emanation of the state. And Mr Justice Voss's position was that can't have been the intention of Parliament, because it would run contrary to everything else we know about how state immunity and sovereign immunity is intended to operate. In the hope of incurring one further brownie point, my lord, I have the limited extract from the transcript, including the passage that I read to your lordship. If I could possibly kindly hand that up. I'm sorry your lordships have received these papers piecemeal. Well, unless I can assist further.
Thank you very much, Mr. Matthews, that's very helpful.
Thank you.
Right, thank you all very much for your interesting and thought-provoking argument. We will reserve our judgment, obviously, and get it to you as soon as we can, but no promises as to when. When you get it in draft, please restrain yourselves from inviting the court to make any changes other than typographical ones, and please pay attention to the terms of the embargo at the top of the judgment. I'm sure you will. But it's important that it's complied with.
Understood.
Thank you very much again.